two types of probate administration. And in today's video, I'm going to go through discussing the two different types of administration and which one is more ideal than the other. My name is Rebekah Coquat, and I'm one of the founding owners of the Coquat Law Firm. And you are watching Coquat TV, Estate Planning and Probate Edition. Once a will is validly proven through the court, which is probate, an administration has to take place, which means determining what the assets are and distributing those assets based on either what the will says or what the estates code says if there's not a will. Now, most people don't know that there are two types of administration. One is called independent administration and one is called dependent administration. And I'm going to go through the process of talking to you about which one is the differences between the independent and the dependent. Now, independent, as it sounds like, is where the executor or the administrator of the estate is able to act independently of the court for the most part. There are definitely going to be steps still that must be taken, documents that need to be filed with the court by the independent executor. However, for the most part, the actions they can take get to be independent from the court. For example, they are able to, in most circumstances, sell property without having to first get court permission. They're able to sell the vehicles. They're able to gather up all the assets and go through and distribute the assets to the beneficiaries without getting court permission. Versus a dependent administration is one in which the court oversees just about every step that the administrator or executor takes in the administrative process. In order to sell real estate, in order to sell vehicles, in order to distribute assets, in order to even close the estate, the administrator or executor must receive permission from the court, which means the attorney has to file a document with the court requesting this permission for whatever it is for, and then getting an order back from the court allowing the executor to act. As you can tell, this takes many more steps with having to go through the court, having to file documents. It takes more steps, it takes more time, and it costs more money for the estate because of this extra time taken. So ideally, independent administration is what you want to have in your probate process. One way to allow this to happen is by specifically having it stated in your last will and testament that you wish for your probate to be an independent administration. So how do you avoid a dependent administration? In Texas, in a will, you are given the ability to specifically state that you wish for your executor to act independently of the court. And this is how we achieve an independent administration in Texas. If you have not put in your will that you want the executor to act independently, during the probate process, it is much harder to accomplish an independent administration. However, there are certain ways for the attorney to request that the court allow the estate to be administered independently. And oftentimes that's done by having all of the beneficiaries along with the executor agree on an independent administration. It is still up to the court's authority and decision as to whether or not it will be allowed to have an independent administration. So ideally, you want to plan on the estate planning side to have put in your will that you want an independent administration. So the attorney's role in an independent administration is mostly guiding the executor or the administrator on what steps need to be taken care of. We are able to tell the client, the executor, what needs to be done, and we can either take care of it ourselves or we can let the executor take care of it themselves. There are certain documents that need to be filed with the court that the attorney would take care of. But overall, once the will is probated and the basic administrative documents have been filed with the court, we tell the executor what needs to be done at that point, and the executor can run with it and take care of things with our oversight and being there to answer any questions along the process. So one of the ways that I frequently see where we're able to give the executor the freedom to take care of things with our oversight is going to be with real estate. They're going to go through the process of trying to find who's going to buy the real estate or use their realtor, but we can handle the preparation of the deed to transfer the asset. So that's kind of where an example of where the executor's taking care of some of it, but we're also helping out on the legal end of it. But we're able to give the executor freedom and the ability to take care of things as much as possible on their own, to not have us involved with every separate step, but that we can be involved as if necessary, and as much as the executor wants us to be involved. So in an independent administration, the relationship between the executor and the attorney is one where we're walking hand in hand and doing our roles, taking care of our paperwork on the attorney end, or the executor's taking care of what they can do on the executor's end as a non-attorney. But we are always available to answer questions and walk the executor through the process. When we wrap up a probate here at the Coquat Law Firm, we always put together a letter to the administrator that sets out all of the different steps that they're going to need to take. But in that letter, we specifically say, if there's anything you want us to take care of for you, we can do it. We're giving the executor the knowledge of what steps need to be taken and letting them know what steps we have to take as the attorneys, but also what they can do free from the attorney helping them at that point. And I find that it just makes for a very easy relationship, and it makes the executor feel very comfortable with having that freedom to be able to take care of some of the things on their own, because they might not want to have to contact us for every little last thing. But they know that we're on the sidelines taking care of what needs to be taken care of on the legal end, and then also available for any questions to help them through the process of that administration. All right, now for a dependent administration, the attorney's role is going to be much more involved because there has to be documents filed with the court, requests to the court for just about every step in the administration for the administrator or the executor to take. For example, if when it comes time to sell property, or let's just stick with selling property, we would have to file an application to sell property with the court. It has to sit in the court's file for a while before the judge sees the application, and then the judge has to sign the order, and then we receive it back. So it's not a quick process. It takes time. It takes our filing plus waiting for the courts to return that order back before the executor can take action on that behalf of the estate. So pretty much the relationship between the executor and the attorney in a dependent is that the attorney has to pretty much help take care of every step of the process, and which makes it much more time-consuming and costly, and just gives the executor less freedom. And then sometimes we don't even know for sure what the outcome will be, because it's ultimately the court's decision at that point, and not as much decision freedom for the executor in a dependent administration. I've had people come in to the office and ask, is this process, the probate process, can I do this on my own? And my recommendation is it's best to have an attorney who specifically handles probate matters, who knows the Texas Estates Code to handle your probate and administrative issues. Because we know what the steps are that need to be taken care of, we know what needs to be done and what does not have to be done. We know the time frames. We know how to deal specifically with creditors and the creditors coming after estates. If you are a person that comes in and you don't do probate, you're not an attorney that handles probate and that kind of matter, then you're not going to know all of those processes and those time frames, and it can become very messy at that point. If you don't follow some of the time frames, you can get in trouble as an executor. You can even be removed as an executor if you haven't filed the right paperwork and the right documents with the court during the time frame that is required. And there's just some specific steps that must be taken in the probate process that you're going to be in the best hands if you have a probate attorney that knows what those steps are. And that way you, as the executor dealing with the estate, can have confidence to know that things are being taken care of the right way, and that you're not going to have to worry that something's going to come up as a problem that could have been avoided by having an attorney that can handle it properly. So some people think it would be advantageous to not hire an attorney to handle the probate administration, and they try to do it on their own. But unfortunately, when I have people come in that have tried to do that, I frequently will see that it's not been done properly, and sometimes it can actually cost them more money to have things fixed by us in the probate courts and redone or changed or just done the right way. It's best to have an attorney from the beginning of the probate process to handle the matter for you. So if you've had a loved one pass away and you're in this situation, the first steps to take are going to be to locate the last will and testament. You're going to want to find out if that loved one had a will. You're going to want to get a death certificate, and you're going to want to contact a probate attorney. When you're going to make an appointment, you bring in all the documentation. If you have a last will and testament, anything that you think would be important for the attorney to see, you're going to sit down and you're going to go over that with the attorney so that way they can advise you on how to do the probate process and get things started. So we've discussed the difference between an independent administration and a dependent administration, and that typically you're going to want to have that independent administration where you have freedom from the court to handle matters more efficiently and just have things taken care of. However, as a reminder, one of the best ways to avoid a dependent administration is to, on the estate planning side, have a will made that specifically says that you want for your administration to be independent. So if you've learned something in this video today, we would like for you to subscribe to the Coquat TV YouTube channel. Also, if you have a specific legal question or a probate that needs to be taken care of at this time, please call our law office. We would be glad to help you.